Right now, across social media, one sentence is spreading faster than the truth. A new immigration law has been approved, and for millions of immigrants, that single sentence is enough to trigger fear, panic, and sleepless nights. You may have seen videos claiming people are already being deported, that green card holders are suddenly at risk, or that one mistake from years ago can now destroy everything overnight. The way it's being framed makes it sound final, sudden, and unavoidable. But here's the critical question no one is stopping to ask. What if the law everyone is panicking about isn't actually law at all? What if nothing has changed yet and the real danger isn't the bill itself, but the misinformation surrounding it? That's exactly what we're going to unpack slowly and clearly because understanding this difference could protect your future, your family, and your peace of mind. If you're feeling overwhelmed right now, that reaction makes sense. Immigration isn't just paperwork, it's your job, your home, your children, and the life you've spent years building in the United States. When headlines suggest all of that could disappear instantly, fear takes over before facts can catch up. But this video is not here to add to that fear. It's here to pause the noise, strip away the exaggeration, and replace confusion with clarity. We are not going to speculate, and we are not going to dramatize. Instead, we're going to walk through what's actually happening, what is not happening, and why understanding the difference matters more right now than ever before. By the end of this video, you'll know exactly where things stand today, whether this situation affects you personally, and what smart, calm steps, if any, you should be considering next. Because in moments like this, accurate information isn't just helpful, it's protective. Before we go any further, it's important to set a clear expectation for what you're about to hear. This is not a warning video designed to scare you into action. This is not a rumor breakdown or a reaction to viral clips. And this is definitely not legal advice. What this is a fact-based explanation of a proposed immigration bill that is being widely misunderstood online. We'll explain what the bill actually is, where it truly stands in the lawmaking process, and why claims of immediate changes are misleading. We'll also talk honestly about why immigration professionals are paying attention to it without exaggeration and without minimizing legitimate concerns. Most importantly, we'll focus on what applies right now, because panic based on incorrect assumptions can lead to rush decisions that cause real harm. So, take a breath. Nothing in immigration law changes overnight. No matter how dramatic a headline sounds, laws move through a defined process with checks, delays, and public visibility at every step. Understanding that process is the first step toward regaining control in a moment when fear is being amplified for clicks. And that's exactly where we'll begin next, by breaking down what this bill actually is and why so many people are reacting to it before it has any legal power at all. Let's slow this down and look at the bill itself. Because once you understand what H.R. 875 actually is, a lot of the fear starts to lose its grip. H.R. 875 is not a rule, not a regulation, and not something that suddenly appeared out of nowhere. It is a proposed piece of federal legislation introduced in early 2025, like thousands of other bills that are introduced during every session of Congress. Its purpose, as written, is to amend certain sections of existing U.S. immigration law, specifically around how DUI-related conduct is treated for non-citizens. That's it. At this stage, it is nothing more than a proposal on paper, and that distinction matters more than most headlines are willing to admit. A bill does not equal a law. A bill has no legal force, no enforcement power, and no immediate effect on anyone's immigration status unless and until it completes every required step of the legislative process. Lawmakers introduce bills for many reasons: political signaling, responding to public pressure, testing policy ideas. But introduction alone changes absolutely nothing for immigrants living their lives today. The reason H.R. 875 has attracted attention is because of what it could do if it ever became law, not because of what it is doing now. Lawmakers supporting the bill argue that it addresses public safety concerns related to impaired driving and immigration enforcement. Whether one agrees or disagrees with that framing, it's important to understand intent without assuming outcome. At this stage, H.R. 875 is simply one of many immigration-related bills being debated, revised, criticized, and scrutinized. No visas have been revoked because of it. No green cards have been canceled. No deportations have been triggered by it. The fear spreading online comes from skipping this entire context and jumping straight to worst-case conclusions, as if proposals automatically become policy. They don't, and they never have. Now, let's talk about where this bill actually stands right now, because this is where misinformation becomes especially dangerous. On June 26, 2025, H.R. 875 passed the U.S. House of Representatives. That fact is real, and it's often the only true part of many viral claims. But passing the House is not the finish line. It's not even close. It's one checkpoint in a long multi-step process designed specifically to prevent sudden or unilateral changes to federal law. After House passage, a bill must move to the Senate, where it is typically reviewed by a specialized committee. In this case, H.R. 875 is currently under review by the Senate Judiciary Committee, the body responsible for immigration and constitutional issues. This review stage can take months. Sometimes it takes longer. Sometimes the bill never leaves committee at all. Here is the most important sentence you need to hear clearly. The Senate has not voted on H.R. 875. Because of that, the bill has not been approved by both chambers of Congress, and because it has not passed both chambers in identical form, it has not been sent to the President. And because it has not been sent to the President, it has not been signed into law. That means there is no new immigration law in effect. There is no change to admissibility rules. There is no change to deportability standards. There is no change to how DUIs are treated today under immigration law. None. Zero. Until every one of those steps happens, H.R. 875 has no legal authority over anyone's life. This is why claims that the law has already been approved are misleading at best and harmful at worst. Immigration law in the United States does not change quietly, instantly, or without notice. When real changes happen, there are hearings, debates, amendments, and extensive public coverage. Attorneys, advocacy groups, and government agencies all have time to analyze what the law means and how it will be implemented. That process hasn't happened yet because the law does not exist yet. What exists is a proposal, and proposals, even controversial ones, often stall, change dramatically, or disappear entirely in the Senate. Understanding this isn't about minimizing concern, it's about putting concern in the right place. The risk right now is not sudden enforcement or immediate deportations. The real risk is reacting to incorrect information and making decisions based on fear instead of facts. And now that you understand where this bill truly stands today, the next question becomes even more important. If H.R. 875 were to eventually become law, what would it actually change and who would it really affect? That's where the conversation gets serious, and that's what we'll walk through next. Now, let's talk about why H.R. 875 is getting so much attention in the first place. Because the concern isn't imaginary, it's just being taken out of context. If this bill were to eventually become law, it would significantly change how DUI-related conduct is treated under U.S. immigration law. Under the proposal, certain DUI offenses would become independent grounds of inadmissibility. In practical terms, that means a non-citizen could be denied a visa, denied entry at the border, or refused re-entry after travel based solely on a DUI, even if that DUI is classified as a misdemeanor under state law. This would be a sharp shift from how immigration law generally functions today, where a single alcohol-related DUI without aggravating factors is not automatically disqualifying. The bill would also create new grounds of deportability, meaning immigration authorities could initiate removal proceedings against non-citizens with DUI histories, regardless of whether the offense occurred recently or many years ago. What makes this proposal particularly serious is how broadly it is written. The consequences would not be limited to felony convictions or repeat offenders. The language of the bill extends to misdemeanor DUIs and in some situations even to cases without a formal conviction. Under H.R. 875, admissions of conduct, statements made during visa interviews, border inspections, or immigration filings could potentially be used to trigger immigration consequences. That means a person could face serious risk not because of a court judgment, but because of how a past incident is discussed or documented. The impact would stretch across many categories: visa applicants abroad, individuals applying for adjustment of status inside the United States, green card holders traveling internationally, and even long-term residents who believed a past mistake was behind them. For some people, even a first-time DUI could become a life-altering immigration event depending on how the law is enforced. Another major concern raised by immigration professionals is the lack of clear waivers or meaningful judicial discretion in the proposal. Immigration judges would have very limited ability to consider rehabilitation, family ties, time passed since the offense, or positive contributions to the community. This creates a rigid system where context matters far less than it does under current law. Even more troubling is the question of retroactivity. H.R. 875 appears to allow past DUI incidents to be used as grounds for immigration penalties, even if those cases were resolved years ago under rules that did not carry immigration consequences at the time. For many immigrants, that uncertainty is deeply destabilizing. It means something they believed was closed and resolved could suddenly resurface with consequences that never existed before. This is why so many immigration attorneys and advocates are watching H.R. 875 closely. Their concern is not limited to future behavior, but to how the bill could reclassify past conduct in a way that fundamentally alters legal expectations. People who made a single mistake, completed their sentence, rehabilitated, and moved forward with their lives could find themselves facing immigration penalties that feel disproportionate and unexpected. The fear is not just about enforcement, it's about fairness, predictability, and whether immigration law should operate without room for human judgment. And to fully understand why this proposal feels so drastic to legal professionals, you need to understand how DUIs are actually treated under current U.S. immigration law today. Because the difference is significant. Under the law that applies right now, a simple DUI is generally not an automatic ground for deportation or inadmissibility. In most cases, a single alcohol-related DUI without additional aggravating factors does not by itself make a non-citizen removable or bar them from immigration benefits. This distinction is critical because immigration law looks not only at the offense, but at the surrounding circumstances. Factors like intent, harm, and pattern of behavior all matter. However, this does not mean DUIs are irrelevant. They can and do create serious immigration problems in specific situations. Multiple DUI convictions can raise concerns about public safety or alcohol dependency. Drug-related DUIs are treated far more harshly and can trigger inadmissibility. DUIs involving injury, property damage, or reckless conduct significantly increase risk. Additional issues such as driving without a valid license or having a child in the vehicle can further complicate a case. DUIs can also affect naturalization applications, where applicants must demonstrate good moral character during the required statutory period. For undocumented immigrants, a DUI arrest often leads to contact with immigration enforcement through local law enforcement systems. Green card holders who travel internationally may face increased scrutiny at re-entry, even if the DUI occurred years earlier. But the key point remains unchanged. Under current law, DUIs are evaluated on a case-by-case basis. Context matters, time matters, rehabilitation matters. Judges and officers retain discretion to weigh the full picture. And that's exactly what H.R. 875 threatens to remove. Understanding this contrast is essential because it explains both why the bill has caused alarm among professionals and why claims of immediate changes are incorrect. The law that governs your status today is still the law in effect, and that fact alone should immediately reduce the sense of urgency being pushed online. To understand why H.R. 875 has sparked such strong reactions from immigration professionals, you have to look beyond the headlines and focus on how dramatically it would change the philosophy behind immigration decisions. For decades, DUI-related cases have been handled with nuance. Immigration judges and officers are trained to look at the full context of a person's life. What happened, why it happened, how long ago it occurred, and what the individual has done since. H.R. 875 moves away from that individualized approach and replaces it with a rigid framework that treats DUI-related conduct in a way that is closer to how the law treats serious violent crimes. That shift is what alarms many attorneys. It's not just about punishment, it's about removing the ability to evaluate people as individuals rather than categories. One of the most troubling aspects of the proposal is the near elimination of judicial discretion. Under H.R. 875, immigration judges would have very limited authority to consider rehabilitation, family hardship, or positive contributions to the community. A judge may be unable to weigh the fact that someone has lived in the United States for decades, has U.S. citizen children, maintained steady employment, and has had no legal issues since a single mistake many years ago. This kind of one-size-fits-all approach raises serious due process concerns because it prioritizes uniform outcomes over fair ones. Many legal experts argue that justice requires flexibility, especially in immigration cases, where the consequences permanent separation from family and home are far more severe than the criminal penalties imposed for the same offense on U.S. citizens. There is also a significant proportionality issue that cannot be ignored. In the criminal justice system, U.S. citizens convicted of a DUI typically face fines, license suspension, mandatory classes, probation, or short-term incarceration. For non-citizens under H.R. 875, the same offense could result in permanent removal from the country, even if no one was harmed. This disparity is a central reason the bill has generated such concern. The punishment in effect becomes exponentially harsher based solely on immigration status. That imbalance doesn't just affect the individual. It affects U.S. citizen spouses, children, and entire families who could face separation as a result. For many advocates, this raises fundamental questions about fairness, equality under the law, and whether immigration enforcement should operate without proportional safeguards. With all of that said, it's critical to come back to the most important message right now. Do not panic. H.R. 875 is not law, and no immigration rules have changed at this time. Despite what social media headlines suggest, your legal rights, your immigration status, and your current protections remain governed by existing law. Panic is understandable, but it is not productive. Acting out of fear, especially fear fueled by incomplete or inaccurate information, can lead people to make rush decisions that harm their long-term interests. Staying calm and informed is far more effective than reacting to every viral claim that appears in your feed. This moment, however, is a good opportunity to be proactive in a responsible way. If you have any criminal history, including a past DUI, it may be wise to consult with an experienced immigration attorney who can review your specific record and explain how current law applies to your situation. For those who are eligible for naturalization, applying for U.S. citizenship can reduce future immigration risk. But this is a decision that should be made carefully and with legal guidance. Green card holders planning international travel should seek advice before leaving the United States, especially if they have any arrests or convictions in their past, because re-entry is often where issues arise. Individuals currently facing DUI charges should ensure that their criminal defense attorney coordinates with an immigration attorney before accepting any plea or resolution, as even small details can carry major immigration consequences. Finally, the most practical advice is also the simplest. Avoid driving under the influence. Responsible choices protect not only your safety but also your immigration future. Preparation, not panic, is what protects you in times of legal uncertainty. And as long as you stay grounded in facts, you put yourself in the strongest position possible, no matter how the political conversation evolves. If you want to stay accurately informed about H.R. 875 and avoid the panic cycle that social media thrives on, the source of your information matters just as much as the information itself. Viral videos are designed to trigger emotion, not understanding. Headlines are often written to maximize clicks, not accuracy. That's why it's essential to rely on official, verifiable sources when tracking something as serious as potential immigration law changes. The most reliable place to monitor H.R. 875 is the official website of the U.S. Congress. There you can see the full text of the bill, its current status, committee activity, and any recorded votes in real time. This eliminates speculation entirely because you are looking directly at the legislative record rather than someone else's interpretation of it. In addition to official government sources, professional organizations play a critical role in translating complex legal developments into practical guidance. Immigration attorneys across the country closely monitor proposed legislation and share insights through reputable channels. Organizations made up of licensed immigration lawyers regularly publish updates explaining not only what is happening, but what it actually means for real people. These explanations are grounded in legal experience, not hype. If H.R. 875 advances, there will be public hearings, committee debates, amendments, and extended discussion in the Senate. All of this takes time and happens in full view of the public. Immigration laws with broad impact do not move quietly or secretly. This is an important reassurance. When real change is coming, there's usually ample warning, giving individuals, attorneys, and advocacy groups time to prepare, respond, and adjust. It's also important to place H.R. 875 within the broader context of U.S. immigration policy. Immigration law is constantly evolving with new bills introduced during nearly every session of Congress. However, a crucial reality often gets lost in online discussions. Most proposed bills never become law. Even bills that pass one chamber of Congress frequently stall, change dramatically, or are abandoned altogether in the other chamber. House passage, while meaningful, does not guarantee final approval. The Senate process is slower and more deliberative, and it often reshapes or halts legislation entirely. That's why early headlines can be misleading. They capture momentum, not outcome. In periods of uncertainty, the quality of information you rely on directly affects the decisions you make. Inaccurate or incomplete information can push people toward rushed choices, canceling travel unnecessarily, delaying applications without reason, or making legal decisions based on fear rather than facts. Accurate fact-based guidance from official sources and qualified professionals is far more valuable than speculation. Another key takeaway is that more secure immigration status generally reduces risk. Permanent residence and, when eligible, U.S. citizenship provide greater stability during times of legal debate. Rather than reacting emotionally to every proposed bill, the most effective approach is long-term planning, compliance with current law, and informed decision-making. Staying prepared, not alarmed, is what allows individuals and families to navigate the immigration system with confidence even when the political landscape feels uncertain. When questions arise, especially during moments like this, it's essential to know where to turn for trustworthy guidance. The U.S. Citizenship and Immigration Services website remains the primary source for accurate information on immigration benefits, forms, processing updates, and official policy guidance. USCIS provides tools that help individuals understand where they stand under current law, including case trackers and published policy manuals. While government hotlines can clarify procedural questions, they do not replace personalized legal advice. When case-specific guidance is needed, consulting a licensed immigration attorney is the safest course of action. For those seeking legal help, there are reliable ways to find qualified professionals. National organizations of immigration lawyers maintain public directories that allow individuals to search for licensed attorneys by location and area of practice. Nonprofit organizations and legal aid providers may also offer low-cost or free assistance to eligible individuals, particularly in vulnerable communities. A critical warning is worth repeating. Avoid notarios, consultants, or anyone who promises guaranteed results or quick fixes. These individuals are not authorized to provide legal advice and often cause serious, irreversible harm. Choosing reputable, verified resources is one of the most important steps you can take to protect both your case and your future. Let's bring everything together clearly, because clarity is what replaces fear. First, H.R. 875 is a proposed bill, not an enacted law. Despite what some headlines claim, it has no legal effect right now. Second, while the bill did pass the House of Representatives, that is only one step in a long legislative process. It has not passed the Senate, it has not been sent to the President, and it has not been signed into law. Until all of those steps happen, current immigration law remains fully in place. Third, if H.R. 875 were ever enacted, it could significantly change how DUI-related conduct affects immigration status, potentially expanding grounds for inadmissibility and deportation in ways that do not exist today. That is why immigration professionals are paying close attention. Fourth, under current law, a simple DUI is generally not an automatic immigration disaster. Context matters. Aggravating factors matter. Discretion still exists. Fifth, because every immigration case is unique, individualized legal advice is essential. A qualified immigration attorney can explain how current law applies to your specific situation and help you make informed decisions. And finally, for those who are eligible, U.S. citizenship offers the strongest long-term protection during periods of legal uncertainty. The most important thing to remember is this: panic helps no one. Fear-driven decisions often create problems where none existed. Staying informed, relying on credible sources, and planning carefully are what protect you and your family. Immigration law can be complex and emotionally charged, especially when misinformation spreads faster than facts. But knowledge, patience, and preparation give you stability. Even when the political conversation feels loud and unpredictable, laws do not change overnight. And when real changes come, there is time to understand them and respond responsibly. You are not powerless in this process, and you are not alone. If this explanation helped bring clarity to a confusing and stressful topic, take a moment to support the channel by liking this video and sharing it with someone who may be feeling uncertain right now. And if you want to stay informed with calm, fact-based updates instead of panic-driven headlines, consider subscribing so you don't miss future videos. Your awareness and preparation matter, and staying grounded in facts is one of the strongest tools you have as immigration laws continue to evolve.